And our top story at 7, unwarranted searches, warranted or not, and whether seemingly extra constitutional powers be granted to the banks. Mzwanele Manyi from the Progressive Professionals Forum has come out strongly against the FICA bill. Manyi says the bill would financially cripple the ANC in the run-up to the 2019 general elections. Through FICA, financial institutions would have the power to investigate questionable transactions. The FICA bill was passed by a parliamentary majority more than 6 months ago, yet President Zuma only recently sent the bill back to Parliament, refusing to sign it into law. And joining us in studio is Mzwanele Manyi, president of the Progressive Professionals Forum, Tsepo Hadima, political analyst, Dr. Danisa Baloyi, the BBC president, and we also have Professor Sipho Siepe. Thanks so much for joining us. You at home, the phone lines are always open on 011-542-2186, and you can join us on social media as well. At the heart of it, Dr. Baloyi, I mean, we saw it got very heated in Parliament, saying that this bill would prejudice what people are termed as politically exposed, and whether that definition would extend to people that are not necessarily black executives. What are your concerns as the BBC?
We worry about the fact that the banks, who already have so much power, have the power extended to them. For instance, they are closing accounts of business people. Our members are having their accounts. 3 more today called me to say they are closed. The problem with that is that once your bank account is closed, you can't defend yourself. The banks say go to court and fight it out. How do you do that when your funds are frozen? So that's exactly what we are saying. They are the judge, jury, and executioner. Theirs, in our view, should be to flag if they see something that is wrong happening within your accounts. And then the state organs that are there through our constitution should take over. But if they do all of that, they are not the police. Why are we wanting to extend this power to them? But before you even go further, I want to dispel this myth that we are against 100% of this bill. In fact, more than 90% of it, we agree with it. We don't want money laundering. We don't want corruption. We don't want the financing of terrorism, which is what it should cover in terms of what the UN Article 52 says.
Yeah, but I mean, some would argue that this is according to international practice, a best practice at least, that we have a financial monetary policy that is very well regulated, and this adds on to that need to protect any form of wrongdoing.
Yeah, no, most definitely for us also as Progressive Professionals Forum, we support the objectives of the bill 100%, all the objectives. The only problem is the how. And that international dispensation by FATF, Financial Action Task Force, is actually very clear that to member organizations, member countries as it were, when you implement these recommendations, you must do so within the confines of your constitution, and you must integrate your operations within the existing legislation. The problem we have with this bill is that this bill first and foremost violates a basic tenet of the Constitution in terms of who is responsible for crime. And let's be very clear that the 2 things that this bill is supposed to be doing in terms of this international standard are 2 criminal things, which is money laundering and financing of terrorism. So those 2 things is not just, and it's criminal, and it is prosecutable as we speak. So we can't have a situation where in South Africa, while we have organs of the state that are responsible for criminality, and for some reason forget about them, then establish a parallel system via banks to take over that role. This is our problem, because you must understand that around this system of security, there's all issues around vetting. Now, if you take a FIC inspector, who says this FIC inspector has been vetted? How do we know that a FIC inspector that comes to your house, that comes into your accounts, is actually an international spy? Who has vetted these people? It's a big risk to South Africans. They get into a house, I mean, imagine, with this warrantless search that they want, that some banks people and all of these people, they make a decision to say, today we're raiding your house. and you are at work and somebody at home calls and says, 20 men are here, they are ransacking the house. And in that ransacking, what are they going to leave? What happens if they leave all kinds of listening devices? This is why it's very important that this piece of work must be done by agents that are properly trained and properly vetted.
But Mzwanele, it already seems like this is a sideshow in the sense that you're objecting to certain aspects of the bill, because in practice the banks are already, exercising.
This is actually, I'm glad to raise that, because you see, the reason they are pressing this thing that it must happen now, is because the banks are aware that they've already flouted the law. They've already implemented things that are illegal. Now they're doing to do Operation Catch-up. The FATF deadline is that only by November 2019 are we coming to inspect. So we've got a whole 2 years. So this whole emergency and crisis and all of that is all about providing cover-up for the banks, because they've already implemented a law that has not been promulgated. That's a problem.
Tsepo, just your assessment, at least, and Professor Siepe as well, and how the ANC MPs who are enjoying the majority could have easily entertained the likes of the Progressive Professionals Forum and highlighted the issues that this particular bill would primarily discriminate against black executives, black politicians, etc. Why has that not happened?
Yeah, maybe I would like to premise it this way, Cindy, that the bill, Financial Intelligence Center Amendment Bill, it is an amendment to an act that exists. So there is no vacuum in South Africa in as far as legislation that combats money laundering and financing of terrorist activities. The legislation that we have today was in fact promulgated in 2001 and came into effect in 2003. So there is no vacuum. It means therefore that this bill not being signed or however delay, there is no vacuum of any kind howsoever in South Africa as far as legislation to that is required. But the point that maybe I want to stress is this. A lot has been said. The issue of warrantless searches, safe to say that property is beyond just immovable property. A bank account is a property. The bank is actually a facilities manager of your property. So what this warrantless searches would in effect mean is that a banking institution, which is a private entity, member of the public, will then be having investigative powers which are reserved for law enforcement agents. And when they analyze your banking transactions, the transactions that you do, that is a search which would have been without any warrant howsoever that indeed they can do that. So therefore, as far as that part is concerned, but yesterday in Parliament, I think correctly so, both the PPF and the BBC did not want to stress that. What they wanted to stress, and the point that was very ably and completely made to Parliament yesterday, was the fact that this bill, it reclassifies a crime into a misdemeanor, because they're speaking about the FIC inspectorate, who even Advocate Gauntlet did admit that, by the way, those FIC inspectors are not trained in crime fighting or investigations of a criminal nature. So therefore the question is, if money laundering is a crime and financing of terrorist activities are a crime, it therefore means you are limited to only deal with them within the criminal justice system. The Constitution of South Africa prescribes that only a law enforcement agent can investigate, and only a national prosecuting authority can prosecute in an open, transparent court headed by an independent judiciary. Therefore, the provision in the bill, which is called the domestic prominent influential person, effectively it vests unfettered power in the hands of a banking institution, and we encourage the viewers at home to please go and download the bill and read the provision on domestic prominent influential person under, which is the classification, the definition, but particularly the provision for risk management and compliance program. Is that section 42? Now, risk management and compliance program, that is where the greatest constitutional mischief is found, in that the banking institution then is given the powers to convict and sentenced. The conviction is to declare you guilty of a crime without you having been prosecuted in an open court, and sentence you, which is the closure of your bank account. But even worse is that all other so-called accountable institutions, which includes lawyers, insurance companies, will henceforth have to cease doing business with you. That cannot be allowed because the Constitution does not allow it. So what does Parliament sit with? Parliament is not sitting with Section 79, as it was argued yesterday. Effectively, they have no bill because the duty to legislate a bill that is constitutionally compliant, that is the duty and the obligation of the legislatures. The separation of powers in South Africa, the president as the executive has no power whatsoever to make laws. But Parliament, when they make laws, they must make laws that are constitutionally compliant. In the event they make a law that is unconstitutional, is invalid. So therefore, what they have to, reality they have to face as Parliament is that today they are sitting with a bill that is not capable of being referred to the president or ascended to the president, and that is something that they need to find a way. And Mr. Manyi, I don't think that he was bluffing yesterday when he said that we will go to the ends of the world to ensure that in the courts they will then have to pronounce on the constitutionality, which we hold course that indeed the bill is unconstitutional, therefore invalid. But there is no vacuum because we have Financial Intelligence Center Act of 2001 in place currently.
Yeah, but that's also part of dislodging the monopoly that the banks are enjoying, that they're a law unto themselves and unfairly targeting, it would seem, at least a particular cohort of people. Your observations yesterday, Professor Sim?
Well, I think the first thing that we should say is that we should congratulate BBC and PPF for taking this initiative to bring this matter to light. And we should also ask ourselves, why have other organizations that always claim to be custodians and champions of constitutionalism, why have they been quiet? And also why there has been a tendency to rush even when there are issues that of constitutionalism that are actually raised. So, and once you start looking at, you start asking those questions, you'll also realize that anything that appears to target black people would always enjoy such agency that you must sign now. But also what Mzwanela was saying, it's also that it appears that the banks themselves have already acted unlawfully, so they are trying to catch up. So it's very important that there's vigilance around that aspect. And all those people whose accounts have been closed without a due process need to actually make themselves available. Actually, they should actually open cases against those banks. So that's number one. The second thing that we must also understand, which relates to why the silence, is that we have not debriefed ourselves after apartheid. That what has happened has been such a serious psychological damage that we don't realize that black people in this country are always under suspicion. So anything that suggests that we must catch them before they do something, in this country, it's always allowed and encouraged. You don't see all these parties, these organizations that are acting. They were not there yesterday to say, let us defend. Even the one that was CASAS, they were actually not saying, these guys are wrong. They were saying, but this is a phrase that came from the Constitutional Court, as if the Constitutional Court is a god. The Constitutional Court, when matters go to them, they may always respond to what has been brought. And there are times when they overlook certain things. So the issue should be whether we are having a situation where there's an overreach by the banks in spaces that are not theirs. So the whole idea of checks and balances, but where you are now having the judge, the prosecutor, and the jury all in one, you should actually say there is actually a problem. And where processes are also not transparent, we expect all these loudmouths on constitutionalism to have actually jumped and say, but wait a bit. But what I found interesting about the legislature yesterday was suddenly them agreeing that they are powerless to say, but this rule requires that we only respond to one thing. If you realize that the law that is going to be passed or something that is going to be given to the president has constitutional flaws, you should know that you must correct something, but make sure that when you ask the president to sign, you ask the president to sign something that is constitutionally compliant. So I didn't hear an argument that says the argument that is presented by both the PPF and BBC were wrong. Instead, it became more issue of technicality. But what is very important is that for us, for once, we now have a black organization now assuming the role that they should actually be playing to defend this democracy, but also to expose the hypocrisy of the so-called constitutionalists in this country.
All right, Professor Siepe, hold the thought. We have Clive Ramatibela-Smith, ANN7 business editor. Clive, thanks so much for joining us. Perhaps just to put it in context and in layman terms, if this bill were to be passed in its current form and the dangers of infringing on one's right to privacy, and that anybody and everybody is susceptible to this kind of scrutiny, and the bank simply having too much power, is it likely that this bill would be adopted in its current form?
Thank you very much, and good evening to my fellow panelists there as well. Cindy, I think this is typically what we have seen in the past. Unfortunately, for the first time, it's been exposed before it even gets passed into Parliament. Previously, South Africa has had to use consulting services in terms of legal advisory when it comes to passing through bills and making sure, obviously, that they get recognized as well. In this particular case, somebody took note of some flaws that were in particularly relating to this particular amendment bill, and therefore they've been brought to the open, and now people can actually understand the kind of things that have been happening in the past. It's the first time. I mean, it's in 2017, and now for the first time, a law has been put to scrutiny because it might just, hinder on people's constitutional rights. And so, just to give you into perspective, South Africa, the financial sector, the financial services in South Africa, ranks amongst the top 10 in the world when it comes to stringent measures, security, and making sure that they abide by the law. Secondly, the JSE itself, as an indice or as an exchange, ranks #1 in the world in terms of security and tightness. It is favored amongst the top 5 in the world of the best security exchanges in the world when it comes to safety and participation of free voluntary money and capitalization. So that means, first and foremost, we have some of the most strongest policies and monetary controls in this country than anywhere else in the world, meaning that we are #1 when it comes to security. So it is very difficult to hide or to bind money out of the country already. So what this bill would be doing would be giving more power, evidently, to the financial service providers, to banking providers, to have even more of a stronger teeth into making sure that people get it harder. Now, let me just get you to something very interesting. Donald Trump, as the president of the United States, says they need to relax laws in the financial sector in the United States. He says he wants to cut it down by 75% because it has continued to protect those at the top and continue to be unfair to those at the bottom. Now, in this country where we have such a huge widening gap of inequality and what powers and controls that people can have in our economy to participate freely, there you are now making even the laws that already have been so strong, so stringent, and making it difficult for business to actually operate. The red tapes that we always talk about making it a possibility for business to participate. Now we're making it even harder for even foreign direct investment to be attracted, for even entrepreneurs to be able to be attracted, for even the guys who are outside the economy who want to participate, who can't because of such laws that make it very impossible for them to participate. And so therefore, if you are supposed to be leading in terms of building entrepreneurs, laws must be able to be relaxed, but most importantly, they must also be protected by the South African Constitution, which protects each and every one of us to be able to trade freely and affordably within our country as well.
Yeah.
But laws have to protect the people. Those laws are made for us as South African citizens. And if we feel that they are not protecting us, something has got to give. It is just a pity that something like that keeps on happening, where the larger community of South Africa, I made the point yesterday that, in my opinion, this will impact on black Africans more than anybody else. Because if they say, if you're married to a politician, or if you work for an institution of government, if you're, who is in government right now? So every one of us by association will be PEPs. But the most important part is that once you've been labeled a PEP, you are always a PEP. You are criminalized without being a criminal. So we have to be cognizant of what this means to the larger society.
The powers that the National Assembly has, though, without the objection from your organization, can they adopt the recommendations that you've made without necessarily further consultation or any other cumbersome process?
This is where rule of law differs from rule by law. If Parliament takes the rule by law approach, where it's more mechanistic, then they will say all they can do is to look at just this clause and they cannot do anything else. But if they understand, beg your pardon, rule of law, which talk to the issue of rationality, it is rational to say you must take this thing for signing when you know very well that there are flaws. I think we need to have a humble parliament. We need to have a parliament that's got humility, that's able to say we did wrong here, and be able to pull back. We have made a recommendation as Progressive Professionals Forum that in fact this bill is competent of being withdrawn and reconceptualized, thrown back to cabinet so that all of these things can be cleared out.
Just last words from you.
Yeah, very briefly, I'd like to say, I don't know how many South Africans are aware that this bill, once enacted, it means that the Chief Justice, the Deputy Chief Justice, the Judge Presidents, the Chief Magistrates, the President, Deputy President, Ministers, all the way to local government, including the from the Speaker all the way. All these three leaders and senior officials of the three branches of state, none of them will now be able to execute their duties and functions without first having to take into account the interest of the banking institution, whether they are not adversely affected, because there is no transparent process that is in the judiciary that can say, you can have a Chief Justice of this country's account being closed, he will have no recourse, he will not even be able to find a lawyer who can represent him in his own court. So what kind of a society is that? That is a true South African Republic, and we are asking, do South Africans really want to live in a country which is ruled by the mob, otherwise known as the banking institutions?
Last words from you, Professor Siep.
Well, I think because of our history, all you have to do in South Africa is to say something is international, and then we get scared, and we want to be part of that. But that actually shows the sense of doubt that we have amongst ourselves. So there's clearly a problem with this bill, and I'm glad that at least we have organizations that have risen and have actually raised that issue. And I hope there are some judges who are watching this, because the fact that something may have passed they should also have the humility to simply saying, maybe even the regulations that we have made have constrained us to do what Mzwanele was saying, that we should have a rationality and the concept of rule of law to be embedded in whatever we do. And what I saw yesterday in Parliament was a resort to technicalities, not to the arguments that were presented. But as I said, that when things are pushed like this, you should know who is going to be suffering. Everything that is pushed quickly instead of a debate. And this country, we're talking about a country that is going to exist for a number of years. And if there are suspicions about the law being wrong, we owe it to ourselves to say, let's relax, because we don't want to be adversely affected and prejudiced unnecessarily and through our own volition.
As always, we appreciate your insight and making the time to join us here, and hopefully we'll extend the debate some other time. But thanks to all our panelists this evening, and for you at home for watching. We take a quick break. We're back with the latest news headlines.